Welcome back to this final part of this 4-part session of Land Law Introduction. When we consider the general principles that I've gone over so far, the idea in this introduction, as I've mentioned before in the previous segment, is to allow you to have an understanding of the principles which underpin the rest of the lecture series, and in particular to know what the issues that are relevant for you to know in the context of being able to answer questions in relation to those topics. So we will now conclude this introduction in relation to the interests that we were mentioning in the last segment, and I flagged up just before we broke on the last segment about legal interests and equitable interests. Again, as a reminder, I said to you, you've got to consider first, what is the interest under discussion? So is it a lease, an easement? And then you want to consider, is it a legal or an equitable interest? Once you've considered that, then you've got to consider, is it registered or unregistered land, which is a matter, of course, for a completely other lecture. What we want to finish with here is considering what are the legal and equitable interests in particular that I am raising. Well, legal interests are interests listed in Section 1 of the Law of Property Act 1925. So these, of course, include freehold and leasehold situations that I mentioned in the first segment of this lecture. So if you're buying or renting, so buying or leasing, it means that that can be a legal interest. So you can buy a property and that purchase amounts to a legal interest. You can lease a property, whether you're buying it on lease or renting it as the case may also be a legal interest. And that tends to be where you're using a deed, as you will discover when we come to those particular lectures. An easement or a right or privilege in or over a legal estate can also be a legal interest. So you can have a legal easement. A charge by way of a legal mortgage. So a mortgage or similar charge may be a legal interest. A right of re-entry. Again, we consider that when we look at leasehold covenants. But a right of re-entry basically is the ability to forfeit the lease and the landlord to retake his premises. A right of re-entry may also be a legal right. Rent charges, which are really outside the scope of the syllabus, may also be a legal right. Now, all other interests which are not listed in Section 1 of the Law of Property Act are equitable interests. And one of the things you may notice is remarkably absent from Section 1 is a covenant. So if you're dealing with any type of covenant, be it leasehold or freehold covenant as a topic to consider, please bear in mind that covenants are always equitable interests. And it is an interest not capable of being a legal interest, as I said, because it is not in Section 1. Generally, though, when you consider equitable interest, and then the vast majority of topics that we'll consider, for example, you will see that the focus in land law as it relates to equitable interest tends to be primarily trusts. And exam questions tend to focus a lot on trusts, which then, of course, means that we will consider trusts in brief also within this introduction. When you look at trusts, the idea is that, of course, there's a whole topic, the law of trust itself, which focus on this. But for the purposes of land law, and in order to understand it, again, I will give a brief overview. When we come to consider co-ownership rights, and in particular co-ownership rights in relation to a trust, again, I will give you a more expanded view of it all. But at the moment, let's just consider the brief background and what we're talking about when we talk about trust. Well, from contract law, you know that the idea of privity of contract is such where one party dealing with another party, generally it is only those two parties within that relationship which have anything to say about whatever is under contractual discussion. But when you look at the exceptions to privity, for example, you will see that the trust operates in the context of one of those exceptions to privity. And the trust works in a way where you have, for example, the trustee who holds property given to him by either the settlor, if it is that the property is being given to him inter vivos whilst he's alive, whilst the person giving it is alive, or the testator, if you're looking at a will, for example. So you have a relationship of a trustee in the middle who's been given property by either a settlor or a testator, and he holds it on trust for a beneficiary, the person who is beneficially entitled. Now, the courts enforced equitable interest against persons who took under the trustee. So, the trustee is the legal owner. On an exam paper, how this manifests itself is that the person who is on the legal title is the trustee. That is who is considered the trustee. And as I said before, a lot of the times when one considers land law and consider the level of difficulty with land law, it is because the concept sometimes seems slightly esoteric and persons therefore feel that they have no grasp or handle on it. But if you understand what the examiner is talking about, you generally will have no problems whatsoever in answering the question. So when, for example, we talk about a trustee in the context of land law, it generally is the person who is the legal owner, that is the person who is the named person on the title deeds. So the court would enforce against buyers generally, except equity's darling. And equity's darling is the buyer who can consider himself a bona fide purchase of a value of a legal estate without notice. Now, who is a bona fide purchase of a value? Well, if we consider this, what we're saying is that the general rule is that where there is a trust situation, the courts will consider that the trustee, the legal title holder, will hold on trust for the beneficiaries if the circumstances give rise to a trust. So, for example, you give me monies to buy a property because for whatever reason you decide you want me to purchase that property in my name. But there's a clear understanding between you and I that even though the property is purchased in my name, you are the true owner of that property. What we have just created then is that you as the settlor has given me the money, the trustee. I have purchased the title in my name, meaning then I am the legal owner. And therefore, as the trustee and the legal owner, I am now holding on trust for you. It means that you, as the legal owner, is the person beneficially entitled to the property. And one of the maxims of equity that you will have learned in your first year is no doubt that where law and equity conflicts, equity prevails. It means that if there is a legal owner and there is a beneficial owner who is different, then the law will consider that the property, of course, belongs to the equitable beneficial owner. As such, therefore, if someone is purchasing property from a legal owner, then the law says that the buyer will be liable to the beneficiary unless that buyer can show that he is a bona fide purchase of a value without notice of the equitable interest. And what that means is that he must show not only that he's a bona fide purchaser, which means that it is an arm's length transaction, market value was paid, and so on, but he must be a purchase of a value showing the market value was paid. Without notice, and notice can take various forms. It can be actual notice. It can be constructive notice. It can be imputed notice. Now that we will look at further when we consider, for example, unregistered land. But for our purposes, so it's a bona fide purchase of a value without notice of the equitable interest. If a purchaser cannot show that he is that bona fide purchase of a value without notice of the equitable interest, then he will not take free and clear of that equitable interest. So that purchaser could expend monies only to discover later that he very much is holding the property on trust for the real owner, meaning you who gave me the money to purchase the property. One point that I would like to also flag up, of course, is that the fact that a mortgage is defined in terms of the bank being the purchaser, it means that the bona fide purchase of a value principle also apply in circumstances where a bank is offering money in order to take a mortgage. Now, in respect of the trust, just by way of brief background, we see that the chancery jurisdiction over land developed because the chancellor would enforce the use, which is the forerunner to the trust. And when you come to do the law of trust, you will consider this area in depth, of course. But for our purposes, we're dealing briefly with it in the land law arena. Now, land was put in trust for several purposes. More often than not, it was to evade the common law and the strictures of the common law. And a range of equitable estates developed in chancery and was enforceable only in the courts of chancery. And so in one piece of land, one person could have a fee simple protected by the common law court, which was the legal fee. Remember, as I said earlier, fee means an estate capable of being inherited, as long as there's someone to inherit it, of course. So one person could have the legal fee. Another person could have a fee simple protected by chancery, which was the equitable fee. Now, until 1873, there were two separate court systems with their own rules and procedures. And under the Judicature Acts of 1873 to 1875, law and equity fused, and the rules and the procedures of both the common law and the courts of equity were now administered in the same court. So you didn't have to consider, for example, your common law remedy first before going for your equitable remedy. The problem with the trust at the time was that you had, for example, persons going off to the Crusades, leaving the land in the care of another person. Now, of course, this would usually be one man going off, leaving the property with another man, because, of course, he couldn't leave it with his wife or some other woman because, of course, women were chattel. So it would be the equivalent of leaving your land with the table, for example. So, of course, what would happen is he'd go off to the crusade for years and years, and by the time he comes back, the person who is left in charge of the land by placing his name on the legal title, of course, would now say, well, it's my land. The problem was that the common law court only recognized the owner at law, and it meant that the person coming back from the crusades simply only had an equitable interest because it was really his land. And so what we saw was the development and the rise of equity, and the concept of the trust developed simply to ensure an equitable resolution. Now, land in the UK is classified as either unregistered or registered land. The two systems are completely separate. Do not confuse the two. And at this point, we are going to pause, because the next lecture will, of course, look at the distinction between registered and unregistered land. We will certainly pick up in respect of the trust when we come to look at co-ownership, but for the moment, we will now pause to later consider registered and unregistered land.